My name is Austin Lux. I'm a criminal defense attorney in Colorado Springs, Colorado, and this is your free consultation on when the court can dismiss a case based on lost or destroyed evidence. So we most often think of evidence as inculpatory, meaning something that's used by the prosecution in a criminal case to prove the guilt of the accused person. But evidence is a two-way street. In addition to being inculpatory, it can be exculpatory, or an indication of somebody's innocence of the charges against them. And if evidence is lost or destroyed, then it can make it much harder for the defendant, the person accused of a crime, for that person to be able to present an effective defense at trial. And this evidence can really be anything. It could be video recordings, interviews, physical evidence, lab results, anything that could be used to show that somebody didn't commit the crimes accused. Now, if evidence is lost or destroyed, then it can violate a person's constitutional right to due process under the law. But before finding a constitutional violation, a judge has to make three findings. First, was the evidence suppressed by the prosecution? And that doesn't have to be the prosecutor himself or herself. It can be any of the agents of the prosecution, which includes the police, even early on in the process. Secondly, did the evidence have an exculpatory value at the time that it was lost or destroyed? And again, exculpatory means that it could be used to show somebody's innocence of a charge. And third, that the defendant is unable to obtain comparable evidence by any reasonably available means. Once all of these three elements are met, then the judge can dismiss a case or impose any other sanctions that the judicial officer believes are appropriate. They have a lot of latitude in these kind of cases to issue a remedy that's fair. So the bigger the constitutional violation, the more drastic the remedy is, all the way up to dismissal of the case entirely. Now, ironically, there's a bit of a catch-22 in this analysis with the second and third elements in that analysis, meaning that if the defense can come in and show that the evidence that was destroyed had an exculpatory value at the time it was destroyed, then it's often harder for them to prove the third prong of the test, which is that they can't obtain comparable evidence by any reasonable means, because they probably had to have some kind of evidence that they showed the judge to prove the second prong of that analysis, and vice versa is true. If they can come in and show the third prong that they can't obtain any comparable evidence, well, then the judge is often going, well, how do I know that that evidence was exculpatory at the time it was destroyed? So that's a bit of the flaw in the logic behind this three-stage test. The one thing I will say, though, is it's been my experience that most judges understand that this is a weird catch-22 analysis, and if you're able to show them that the evidence that you're seeking showed a significant part of the allegations, then they're likely to infer that that evidence is going to be exculpatory. And that makes sense, right? So if, for example, we're talking about some video footage of a traffic accident that was observed by police officers, but maybe never collected or was collected but then destroyed at the police department in one way or another, then the judge is going to assume that that is going to have some exculpatory value because it shows the entire incident itself. Now, the district attorney might get up and argue that this is inculpatory because it shows the accused person getting into the car accident, but the defense is going to make the exact opposite argument, right? That this is exculpatory because it shows some intervening factor, somebody turning in front of you or causing the accident themselves. So that's the standard for when a judge can dismiss a case based on lost or destroyed evidence. It's a significant remedy, but it's appropriate if there is a constitutional violation. Once again, my name is Austin Lux. I'm a criminal defense attorney in Colorado Springs, Colorado. I believe in the Constitution, and I want you to know your rights and the law.